Question 1. The review process indicates a potential gap in a Florida real estate brokerage data protection practices. To address this, what is the most prudent and legally compliant course of action for the brokerage to ensure the cybersecurity and protection of client data? Option A. Postpone any significant enhancements to data security protocols until a data breach incident occurs, at which point a reactive response plan will be initiated. Option B. Rely on the brokerage's general IT security software and policies, assuming they are adequate for protecting sensitive real estate client information without a specific review. Option C. Conduct a comprehensive cybersecurity and data protection impact assessment, identifying all client data collected, its storage locations, access controls, and existing security measures, followed by a formal risk assessment and the development of a detailed data protection plan aligned with Florida's regulatory framework. Option D. Focus exclusively on implementing measures to prevent external cyber attacks, such as phishing and malware, while overlooking potential internal data mishandling by employees. The correct answer is C. Conduct a comprehensive cybersecurity and data protection impact assessment, identifying all client data collected, its storage locations, access controls, and existing security measures, followed by a formal risk assessment and the development of a detailed data protection plan aligned with Florida's regulatory framework. Explanation. The review process indicates a potential vulnerability in how a Florida real estate brokerage handles client data, specifically concerning cybersecurity and data protection. This scenario is professionally challenging because it requires balancing efficient business operations with the stringent legal and ethical obligations to protect sensitive client information. A failure to do so can lead to significant financial penalties, reputational damage, and loss of client trust, all of which are critical to a brokerage success in Florida. The best approach involves a comprehensive, proactive assessment of the brokerage's current cybersecurity measures against established best practices and Florida's specific data privacy regulations. This includes identifying all types of client data collected, where it is stored, how it is accessed, and the existing security protocols. The subsequent step is to conduct a formal risk assessment to pinpoint potential threats and vulnerabilities, followed by the development and implementation of a robust data protection plan. This plan should outline specific technical safeguards, e.g., encryption, firewalls, secure access controls, administrative policies, e.g., employee training, data retention schedules, and incident response procedures. This approach is correct because it directly addresses the core of the issue by systematically evaluating and strengthening the brokerage's defenses in alignment with Florida's legal framework, which mandates reasonable security measures to protect consumer data. It prioritizes a thorough understanding of the risks and a structured plan to mitigate them, reflecting a commitment to compliance and client welfare. An incorrect approach would be to assume that existing general IT security measures are sufficient without a specific review tailored to real estate data and Florida's requirements. This fails to acknowledge that real estate transactions involve highly sensitive personal and financial information that may be subject to specific protections beyond standard business IT security. Another incorrect approach is to focus solely on external threats, such as hacking, while neglecting internal risks like employee negligence or accidental data breaches. Florida law expects brokerages to implement measures that address both internal and external vulnerabilities. Finally, delaying the implementation of enhanced security measures until a breach occurs is a critically flawed strategy. This reactive stance is not only ethically questionable, but also legally insufficient, as Florida law implies a duty to implement reasonable preventative measures. Professionals should adopt a decision-making process that begins with understanding the specific regulatory landscape governing their practice in Florida. This involves identifying all applicable laws and guidelines related to data privacy and cybersecurity. Next, they should conduct a thorough impact assessment, much like the one described in the correct approach, to understand what data is held, how it is processed, and the potential consequences of a breach. This assessment should then inform the development of a tailored security strategy that is both practical and compliant. Regular review and updates to security protocols are essential, as the threat landscape and regulatory requirements are constantly evolving. Question 2. Performance analysis shows a Florida real estate broker is representing a buyer interested in a commercial property in Miami-Dade County. The buyer intends to operate a niche retail business that requires specific operational characteristics not immediately apparent from the property's current use. What is the most prudent course of action for the broker to ensure the buyer's investment is compliant with local land use regulations? Option A. Conduct a thorough review of the Miami-Dade County zoning ordinances and consult with the local planning and zoning department to confirm the permitted uses and any restrictions that would affect the buyer's intended business operations. Option B. Recommend that the buyer purchase the property and then pursue any necessary zoning changes or variances after closing, as this is a common practice for new business owners. Option C. Advise the buyer to proceed with the purchase, assuming that if the seller has been operating a business there, the buyer's intended use will also be permissible under Miami-Dade County zoning laws. Option D. Rely on general knowledge of commercial zoning in Florida, as specific municipal details are unlikely to present significant obstacles for a common retail business. The correct answer is A. Conduct a thorough review of the Miami-Dade County zoning ordinances and consult with the local planning and zoning department to confirm the permitted uses and any restrictions that would affect the buyer's intended business operations. Explanation. Scenario analysis. This scenario presents a professional challenge for a Florida real estate broker because it requires navigating the complex interplay between a client's desires and the legally binding zoning ordinances of a specific municipality within Florida. The broker must act as a fiduciary to the client, while also upholding the law and advising the client on the practical implications of land use regulations. Failure to do so can lead to significant legal repercussions for both the client and the broker, including potential lawsuits, loss of commission, and disciplinary action from the Florida Real Estate Commission. The broker's judgment is critical in ensuring the client's investment is sound and compliant. Correct approach analysis. The best professional approach involves proactively identifying and thoroughly investigating the relevant zoning ordinances of the specific Florida municipality where the property is located. This includes understanding permitted uses, setback requirements, height restrictions, and any potential future land use plan amendments that might affect the property's value or usability. The broker must then clearly communicate these findings to the client, explaining how the existing zoning laws directly impact the client's intended use of the property, and advising on the feasibility and potential challenges of obtaining any necessary variances or rezonings. This approach is correct because it aligns with the broker's fiduciary duty to act in the client's best interest by providing accurate, legally relevant information and expert guidance, thereby enabling informed decision-making and mitigating future risks. It also adheres to Florida Statutes Chapter 475, which mandates that licensees act honestly and truthfully and possess the competence to advise clients on matters related to real estate transactions. Incorrect approaches analysis. Advising the client to proceed with the purchase based solely on the seller's assurances without independent verification of zoning compliance is professionally unacceptable. This approach fails to fulfill the broker's duty of due diligence and can lead to the client acquiring a property that cannot be used as intended, violating Florida's consumer protection laws and the broker's ethical obligations. Relying on general knowledge of Florida zoning laws without investigating the specific municipal ordinances is also a failure. Zoning regulations are highly localized, and what is permissible in one Florida county or city may be strictly prohibited in another. This lack of specificity constitutes negligence and a breach of professional competence, suggesting that the client can easily obtain a variance or rezoning after the purchase, without first confirming the likelihood and process involved with the local planning department, is misleading and potentially harmful. This approach bypasses essential pre-purchase due diligence and exposes the client to significant uncertainty and potential financial loss, violating the principle of providing accurate and realistic advice. Professional reasoning. Professionals should employ a systematic due diligence process. This begins with clearly understanding the client's objectives for the property. Next, the professional must identify the specific geographic location and research all applicable local, county, and state regulations that govern that area. For zoning and land use in Florida, this means consulting the official zoning maps and ordinances of the relevant municipality and county. The professional should then analyze how these regulations align with or conflict with the client's objectives. Any discrepancies or potential issues must be clearly communicated to the client, along with an assessment of the feasibility and process for addressing them. This empowers the client to make an informed decision based on a comprehensive understanding of the legal landscape. Question 3. The monitoring system demonstrates that a Florida real estate broker is preparing to advise a client on the listing price for a single-family residence in a well-established suburban neighborhood. The property has no unique architectural features and has not been recently renovated. Which valuation method, when applied correctly, best aligns with the broker's ethical and legal obligations in Florida to provide accurate market representation? Option A, income approach. Option B, replacement cost method. Option C, cost approach. Option D, comparative market analysis. The correct answer is D, comparative market analysis. Explanation. This scenario is professionally challenging because a real estate licensee in Florida must accurately and ethically represent property value to clients, adhering to Florida's specific licensing laws and regulations. Misrepresenting value can lead to significant financial harm to clients and disciplinary action against the licensee. The core challenge lies in selecting the most appropriate valuation method given the property's characteristics and the purpose of the valuation. The most appropriate approach in this scenario is the comparative market analysis. This method is best suited for residential properties, particularly those that are unique or have limited comparable sales data, as it focuses on recent sales of similar properties in the immediate vicinity. Florida real estate law emphasizes the importance of providing clients with accurate and reliable information. A comparative market analysis, when performed diligently by a licensed Florida broker, directly aligns with the ethical duty to represent the client's best interests by offering a realistic assessment of market value based on current, localized data. This approach is a fundamental tool for brokers in advising sellers on listing prices and buyers on offering prices, directly supporting the fiduciary duty owed to clients. Using the income approach would be inappropriate and potentially misleading. This method is primarily designed for income-producing properties, such as apartment buildings or commercial spaces, where the value is derived from the potential rental income. Applying it to a single-family residence without a rental history or clear income-generating potential would result in an inaccurate and irrelevant valuation, failing to meet the professional standard of care required by Florida law. The cost approach would also be an inappropriate primary method for this scenario. This approach estimates value by calculating the cost to replace or reproduce the property, minus depreciation, plus land value. While it can be useful for unique properties like new construction or special-purpose buildings, where comparable sales are scarce, it is generally less reliable for older residential properties where market conditions and buyer preferences play a more significant role in determining value than the cost of construction. Relying solely on this method for a typical single-family home in Florida would not accurately reflect what a buyer is willing to pay in the current market, thus failing to provide the client with actionable and relevant information as mandated by professional conduct standards. Professional reasoning in such situations requires a systematic evaluation of the property type, its intended use, and the availability of relevant data. A Florida real estate professional should first consider the primary purpose of the valuation. For a standard residential property, the comparative market analysis is the industry standard and most reliable method. If the property has unique characteristics or is an income-producing asset, then the other approaches might be considered, but always with an understanding of their limitations and applicability to the specific Florida market context. The licensee must exercise professional judgment to select the method that best reflects the current market value and provides the most useful information to the client. Question 4. Investigation of a property transaction in Florida reveals that a buyer is seeking to understand the implications of different ways they could hold title. Which of the following explanations most accurately distinguishes between fee simple, leasehold, joint tenancy, and tenancy in common ownership under Florida law? Option A. Fee simple represents the highest form of ownership, granting the owner all rights to possess, use, and dispose of the property indefinitely. Leasehold grants the right to possess and use property for a specific period under a lease agreement. Joint tenancy involves co-ownership with the right of survivorship, requiring the four unities time, title, interest, possession. And tenancy in common involves co-ownership of distinct, undivided interests that can be inherited independently, without a right of survivorship. Option B. Fee simple ownership means the property is leased for a specific period. Leasehold is when multiple parties own the property with the right of survivorship. Joint tenancy is when each owner has an undivided interest that can be inherited, but without the right of survivorship. And tenancy in common is the highest form of ownership with full rights. Option C. Fee simple ownership means the property is leased for an indefinite term. Leasehold is when multiple parties own the property with the right of survivorship. Joint tenancy is when each owner has an undivided interest that can be inherited. And tenancy in common is the highest form of ownership with full rights. Option D. Fee simple represents the highest form of ownership, granting the owner all rights to possess, use, and dispose of the property indefinitely. Leasehold grants the right to possess and use property for a specific period under a lease agreement. Joint tenancy involves co-ownership with the right of survivorship, but it can be inherited by heirs. And tenancy in common involves co-ownership of distinct, undivided interests that automatically pass to the other co-owners upon death. The correct answer is A. Fee simple represents the highest form of ownership, granting the owner all rights to possess, use, and dispose of the property indefinitely. Leasehold grants the right to possess and use property for a specific period under a lease agreement. Joint tenancy involves co-ownership with the right of survivorship, requiring the four unities: time, title, interest, possession. And tenancy in common involves co-ownership of distinct, undivided interests that can be inherited independently, without a right of survivorship. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires a real estate licensee to accurately advise clients on the implications of different property ownership structures under Florida law. Misunderstanding or misrepresenting these distinctions can lead to significant legal disputes, financial losses for clients, and disciplinary action against the licensee. The core challenge lies in translating complex legal concepts into clear, actionable advice tailored to the client's specific circumstances and goals. Correct approach analysis. The best professional approach involves clearly explaining the fundamental differences between fee simple, leasehold, joint tenancy, and tenancy in common ownership as defined by Florida statutes and common law. This includes detailing the rights and responsibilities associated with each, such as the duration of ownership, the right of survivorship, and the ability to convey or inherit the property. For fee simple, the explanation should highlight the absolute ownership rights. For leasehold, the focus should be on the right to possess and use property for a defined term under a lease agreement, without ownership. For joint tenancy, the emphasis should be on the unities of time, title, interest, and possession, and the crucial right of survivorship. For tenancy in common, the explanation should stress the distinct, undivided interest each tenant holds, the ability to convey or inherit their share independently, and the absence of a right of survivorship. This comprehensive and accurate explanation empowers clients to make informed decisions aligned with Florida's property law. Incorrect approaches analysis. One incorrect approach would be to focus solely on the duration of possession without distinguishing between ownership rights and the right to occupy. This fails to address the core legal distinctions between owning property, fee simple, joint tenancy, tenancy in common, and merely having the right to use it for a period, leasehold. This oversight can lead clients to believe they have ownership rights when they only have a possessory interest, violating Florida's disclosure requirements. Another incorrect approach would be to conflate joint tenancy with tenancy in common by stating that both automatically grant the right of survivorship. This is a critical error under Florida law, as the right of survivorship is a defining characteristic of joint tenancy, but is absent in tenancy in common, where interests pass to heirs. Misrepresenting this can lead to unintended inheritance outcomes and legal challenges. A third incorrect approach would be to describe fee simple ownership as having limitations on the owner's ability to sell or transfer the property without the consent of other parties, unless specific encumbrances are present. Fee simple, by definition, grants the highest degree of ownership, and introducing such limitations without a clear legal basis, like a specific deed restriction or a co-ownership agreement not inherent to fee simple itself, misrepresents the fundamental nature of this ownership type and could mislead clients about their property rights. Professional reasoning. Professionals should always prioritize providing accurate, legally sound information. When advising on property ownership types in Florida, the decision-making process should involve 1. Identifying the specific legal definitions and implications of each ownership type under Florida law. 2. Tailoring the explanation to the client's stated goals and circumstances. 3. Ensuring clarity and avoiding jargon where possible, or explaining it thoroughly. 4. Confirming the client's understanding of the information provided. 5. Documenting the advice given. This systematic approach ensures compliance with Florida's real estate licensing laws and ethical standards, protecting both the client and the licensee. Question 5. Comparative studies suggest that understanding the nuances of property classification is crucial for effective real estate practice in Florida. A developer is marketing a large tract of land that includes numerous single-family homes, a central community pool, a clubhouse for residents, and several small, leased retail spaces catering exclusively to the residents of the development. Based on Florida's real estate classification, how should a licensee primarily categorize this property? Option A, agricultural. Option B, industrial. Option C, residential. Option D, commercial. Correct answer is C, residential. Explanation: scenario analysis. This scenario presents a professional challenge because it requires a real estate licensee to accurately identify the primary classification of a property based on its intended use and the surrounding context, which can sometimes be ambiguous. Misclassifying a property can lead to significant legal and ethical repercussions, including potential violations of Florida's real estate licensing laws and regulations, and can negatively impact the client's transaction by misrepresenting the property's suitability for their needs. Careful judgment is required to distinguish between the core purpose of the property and any secondary or incidental uses. Correct approach analysis. The best professional practice involves classifying the property based on its predominant use and the intent of the owner or developer, aligning with Florida's established categories for real estate. In this case, the property's primary function as a place for people to live, with ancillary amenities like a community pool and clubhouse, clearly designates it as residential. Florida Statute 475, which governs real estate brokerage, implicitly supports this by defining residential property as property containing dwelling units. The focus remains on the primary purpose of habitation. Incorrect approaches analysis. Classifying the property as commercial solely because it includes amenities like a pool and clubhouse is incorrect. While these are commercial-type amenities, they serve to enhance the residential living experience and are incidental to the primary residential purpose. This approach fails to recognize the predominant use. Classifying it as industrial is clearly incorrect as there is no manufacturing, processing, or warehousing activity occurring. Classifying it as agricultural is also incorrect as there is no cultivation of land or raising of livestock as the primary purpose. These misclassifications would violate the principle of accurately representing property types as understood within the Florida real estate market and regulatory framework. Professional reasoning. Professionals should approach property classification by first identifying the primary purpose for which the property is intended or used. They should then consider the surrounding context and any secondary uses. When in doubt, consulting Florida Statute 475 and relevant case law or seeking guidance from experienced brokers or legal counsel is advisable. The goal is always to provide accurate and transparent information to clients and to adhere strictly to the legal definitions and classifications within the state. Question 6. The investigation demonstrates that a prospective buyer, who is a licensed real estate broker in Florida, has explicitly instructed their agent to only show them properties in neighborhoods that are predominantly of a specific racial demographic, stating, "I don't want to see anything outside of this area. It's just not for me." The agent is now unsure how to proceed. Which of the following actions best represents the agent's professional and legal obligation in this situation? Option A. Immediately inform the buyer that their request violates Florida's Fair Housing Act and refuse to show properties based on racial preference, explaining that all properties must be shown without regard to race. Option B. Agree to the buyer's request, but subtly steer them towards properties within the desired demographic while avoiding direct discussion of race. Option C. Proceed with showing properties as requested, assuming the buyer's preference is a personal choice and not a discriminatory act that requires intervention. Option D. Politely decline to work with the buyer due to their stated preference without explaining the legal implications of their request. The correct answer is A. Immediately inform the buyer that their request violates Florida's Fair Housing Act and refuse to show properties based on racial preference, explaining that all properties must be shown without regard to race. Explanation. This scenario presents a professional challenge because it requires a real estate broker to navigate a delicate situation involving a potential violation of fair housing laws, while also managing client relationships and business operations. The broker must act decisively to uphold legal and ethical standards without alienating a client or jeopardizing their business. Careful judgment is required to balance legal compliance with client service. The best approach involves immediately and directly addressing the client's discriminatory request with a clear explanation of the legal prohibitions. This approach is correct because it prioritizes compliance with the Fair Housing Act of 1968, as implemented in Florida. The act prohibits discrimination in the sale, rental, and financing of dwellings based on race, color, religion, sex, familial status, or national origin. By refusing to participate in the discriminatory act and educating the client on the legal ramifications, the broker upholds their ethical and legal obligations. This proactive stance prevents the brokerage from becoming complicit in a violation and establishes a clear boundary for acceptable client behavior. An incorrect approach involves agreeing to the client's request while attempting to subtly steer the client towards non-discriminatory choices. This is professionally unacceptable because it implies a willingness to consider the discriminatory request, even if the intent is to later redirect the client. This could be interpreted as tacit approval and still exposes the brokerage to liability if the client perceives the subtle steering as discriminatory itself. Furthermore, it fails to provide the client with a clear understanding of the legal boundaries, potentially leading to future misunderstandings or further discriminatory requests. Another incorrect approach involves ignoring the discriminatory request and proceeding with the transaction as if the comment was never made. This is professionally unacceptable because it constitutes a failure to act when a potential fair housing violation is identified. By not addressing the discriminatory intent, the broker allows the discriminatory sentiment to persist and potentially influence the transaction, even if indirectly. This inaction can lead to a violation of the Fair Housing Act and exposes the brokerage to significant legal penalties and reputational damage. A final incorrect approach involves politely declining to work with the client due to their discriminatory request without providing any explanation of the legal basis. While the broker has the right to refuse service in certain circumstances, failing to educate the client about fair housing laws misses a crucial opportunity to uphold the principles of non-discrimination and prevent future violations. This approach, while avoiding direct complicity, does not actively promote compliance with fair housing regulations. Professionals should employ a decision-making framework that prioritizes legal compliance and ethical conduct. When faced with a potentially discriminatory request, the first step is to identify the specific protected class being targeted. Next, the professional must consult relevant fair housing laws and regulations, such as the Florida Fair Housing Act. The professional should then clearly and unequivocally refuse to engage in any discriminatory practice, explaining the legal prohibitions and potential consequences to the client. Documenting the interaction and the broker's response is also a critical step in protecting both the client and the brokerage. Question 7. Assessment of a Florida residential property transaction reveals visible signs of potential environmental concern, including an unusual chemical odor emanating from a portion of the backyard and a patch of discolored soil near an old outbuilding. The seller has verbally assured the buyer's agent, a licensed Florida broker, that there have never been any environmental problems with the property. The buyer is eager to close quickly. What is the most prudent course of action for the Florida broker representing the buyer? Option A. Rely on the seller's verbal assurances and proceed with the transaction, as the buyer is eager to close quickly. Option B. Advise the buyer to ignore the visible signs and the odor, as the seller has provided verbal assurances and the buyer wants a fast closing. Option C. Advise the buyer to obtain a professional Phase I environmental site assessment to investigate the property's environmental history and potential contamination, and explain the implications of the visible signs. Option D. Recommend that the buyer forego any environmental testing to expedite the closing process and avoid additional costs. The correct answer is C. Advise the buyer to obtain a professional Phase I environmental site assessment to investigate the property's environmental history and potential contamination, and explain the implications of the visible signs. Explanation. Scenario analysis. This scenario presents a professional challenge for a Florida real estate broker due to the potential for undisclosed environmental hazards impacting property value and buyer safety. Florida law, particularly concerning disclosure and environmental protection, mandates that brokers act with honesty, fairness, and due diligence. Failure to address potential environmental issues can lead to significant legal liability, ethical breaches, and damage to professional reputation. The broker must navigate the complexities of environmental regulations and their practical implications for real estate transactions. Correct approach analysis. The best professional approach involves proactively identifying and disclosing potential environmental concerns to the buyer. This entails advising the buyer to conduct independent environmental assessments, such as a Phase I environmental site assessment, to investigate the property's history and potential contamination. This approach aligns with Florida Statute 475, which requires licensees to disclose all known material facts that affect the value of residential property and the general ethical duty of care owed to clients. By encouraging professional assessments, the broker facilitates informed decision-making by the buyer and mitigates their own liability. Incorrect approaches analysis. One incorrect approach is to rely solely on the seller's verbal assurances that there are no environmental issues. This fails to meet the broker's affirmative duty of due diligence and disclosure. Florida law does not permit reliance on mere verbal statements when material facts are at issue, especially concerning potential environmental hazards that could impact health and safety or property value. This approach exposes the buyer to undisclosed risks and the broker to potential claims of negligence and breach of fiduciary duty. Another incorrect approach is to ignore the visible signs of potential environmental concern, such as unusual odors or discolored soil, and proceed with the transaction without further investigation. This demonstrates a lack of professional care and a disregard for potential material facts. Florida licensees are expected to observe and report visible conditions that may indicate environmental problems. Ignoring such signs violates the duty to disclose known material facts and can lead to significant legal repercussions for the broker. A third incorrect approach is to advise the buyer to forego any environmental testing to expedite the closing process. This prioritizes the transaction's speed over the buyer's well-being and right to information. Such advice is ethically unsound and legally risky, as it actively discourages the buyer from uncovering potentially critical information about the property's condition. This directly contravenes the broker's obligation to act in the best interest of their client and to ensure they are making an informed purchase. Professional reasoning. Professionals in Florida real estate should adopt a risk-aware and disclosure-focused mindset. When presented with any indication of potential environmental concerns, the primary professional responsibility is to ensure the buyer is fully informed and empowered to investigate. This involves recommending professional environmental assessments and facilitating access for such investigations, rather than attempting to bypass or downplay potential issues. The decision-making process should always prioritize transparency, due diligence, and the client's informed consent, even if it means a longer or more complex transaction. Question 8. Risk assessment procedures indicate that a licensed real estate broker in Florida is assisting a client who wishes to lease out a detached structure on their property. The tenant has expressed interest in using the structure to operate a small online retail business, with occasional in-person client meetings. The broker is considering drafting a standard residential lease agreement for this situation. Based on Florida law, what is the most appropriate course of action for the broker? Option A. Draft a lease agreement that combines elements of both residential and commercial leases, as the property will have dual usage. Option B. Proceed with a residential lease agreement, as the structure is a separate dwelling unit and the tenant will reside there temporarily for business purposes. Option C. Use a generic lease template that is commonly used for rental properties in Florida, without specific consideration for the tenant's intended business operations. Option D. Accurately classify the lease based on the tenant's intended business use and draft a commercial lease agreement, ensuring compliance with Florida statutes governing commercial tenancies. The correct answer is D. Accurately classify the lease based on the tenant's intended business use and draft a commercial lease agreement, ensuring compliance with Florida statutes governing commercial tenancies. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a broker to navigate the nuances of lease agreements, specifically distinguishing between a residential lease and a commercial lease, and understanding the implications of each under Florida law. Misclassifying the lease can lead to significant legal and financial repercussions for both the landlord and the tenant, potentially resulting in disputes, invalid lease terms, and regulatory penalties. Careful judgment is required to ensure compliance with Florida's landlord-tenant laws and to protect the interests of all parties involved. Correct approach analysis. The best professional practice involves meticulously reviewing the intended use of the property and the terms of the proposed agreement to accurately classify it as either a residential or commercial lease under Florida statutes. This approach is correct because Florida law provides distinct legal frameworks and protections for residential tenancies, primarily Chapter 83, Part Roman II, Florida statutes, that differ significantly from commercial leases. A residential lease is for a dwelling unit, while a commercial lease is for property used for business purposes. Properly identifying the lease type ensures that the agreement adheres to the specific disclosure requirements, notice periods, and remedies applicable to that category, thereby upholding legal compliance and ethical representation. Incorrect approaches analysis. One incorrect approach involves assuming the lease is residential simply because the property is a single unit, without verifying the tenant's intended use. This fails to acknowledge that Florida law differentiates leases based on purpose. If the tenant intends to operate a business, even in a single unit, it constitutes a commercial lease, and applying residential landlord-tenant provisions would be a violation of Florida statutes. Another incorrect approach is to proceed with drafting a lease agreement based solely on a verbal agreement about the property's use, without a written document clearly defining the terms and intended purpose. This is professionally unacceptable as it creates ambiguity and increases the risk of disputes. Florida law, while not always requiring leases to be in writing, strongly favors written agreements, especially for commercial purposes, to clearly outline rights and obligations. Relying on verbal agreements for significant contractual matters like lease type is a failure to exercise due diligence and uphold professional standards. A further incorrect approach is to use a generic lease template without confirming its suitability for either a residential or commercial tenancy in Florida. Generic templates may not incorporate the specific statutory requirements mandated by Florida law for either type of lease, such as specific clauses related to security deposits, eviction procedures, or landlord responsibilities, leading to noncompliance. Professional reasoning. Professionals should adopt a systematic approach to lease agreement preparation. This involves 1. Thoroughly understanding the client's needs and the property's characteristics. 2. Ascertaining the tenant's intended use of the property. 3. Consulting relevant Florida statutes, e.g., Chapter 83, Parts I and Roman II, to understand the legal distinctions and requirements for residential versus commercial leases. 4. Drafting a clear, comprehensive written lease agreement that accurately reflects the property's classification and the agreed-upon terms, ensuring all statutory disclosures and provisions are included. 5. Advising clients on the legal implications of the chosen lease type. Question 9. Regulatory review indicates that a Florida real estate licensee is representing the seller in a residential property transaction. During a final walkthrough, the buyer discovers a significant, previously undisclosed leak in the roof that was not apparent during the initial inspection period. The purchase agreement contains standard clauses regarding inspections and closing. What is the most appropriate course of action for the licensee to advise the parties? Option A. Advise the seller to immediately offer a price reduction to the buyer to cover the cost of repairs. Option B. Advise both the buyer and the seller to consult with their respective attorneys to review the purchase agreement and the implications of the newly discovered defect. Option C. Advise the buyer to waive the defect and proceed with closing as scheduled. Option D. Advise the seller to attempt to fix the leak themselves before closing without informing the buyer of the specific issue. The correct answer is B. Advise both the buyer and the seller to consult with their respective attorneys to review the purchase agreement and the implications of the newly discovered defect. Explanation. This scenario presents a professional challenge because it requires a real estate licensee to navigate the enforceability of a contract when a material defect is discovered after the agreement has been executed, but before closing. The licensee's actions directly impact the legal rights and financial well-being of both the buyer and seller, necessitating a thorough understanding of Florida contract law and disclosure obligations. Careful judgment is required to ensure compliance with Florida statutes, Chapter 475, and relevant case law concerning contract validity and remedies. The best professional approach involves advising the parties to seek independent legal counsel to review the purchase agreement and the newly discovered defect. This approach is correct because Florida law emphasizes the importance of legal advice in complex contractual matters, especially when issues arise that could affect enforceability or necessitate contract modification or termination. By directing both parties to their respective attorneys, the licensee fulfills their duty to act with honesty, fairness, and integrity, avoiding the unauthorized practice of law and ensuring that the parties' rights are protected by qualified legal professionals. This aligns with the ethical obligations of a Florida real estate licensee to facilitate transactions transparently and without misrepresentation. An incorrect approach would be for the licensee to unilaterally advise the seller on how to proceed with disclosing the defect or to suggest specific remedies to the buyer, such as a price reduction or repair by the seller. This is professionally unacceptable because it constitutes the unauthorized practice of law in Florida. Licensees are not attorneys and cannot provide legal advice or interpret contract terms in a way that dictates legal outcomes. Doing so could lead to misinterpretations, disputes, and potential liability for the licensee and the parties involved. Another incorrect approach would be to ignore the discovered defect and proceed with closing as if nothing has changed. This is ethically and legally flawed because it violates the seller's duty to disclose material defects and potentially misleads the buyer. Florida law requires full disclosure of known material defects that could affect the value or desirability of the property. Failing to disclose can render the contract voidable and expose the seller and the licensee to legal action. A third incorrect approach would be to pressure the buyer to waive their right to inspect or to accept the property as is, without proper legal consultation, especially after a material defect has been identified. This is unacceptable as it undermines the buyer's contractual rights and the principle of informed consent. A licensee's role is to facilitate a transaction based on full disclosure and understanding, not to coerce or mislead parties into unfavorable agreements. The professional reasoning framework for such situations should involve 1. Recognizing the potential legal implications of the discovered defect. 2. Understanding the licensee's role as a facilitator, not a legal advisor. 3. Prioritizing the party's right to seek independent legal counsel. 4. Communicating clearly and ethically with all parties involved, emphasizing the need for legal guidance to resolve contractual issues. 5. Documenting all communications and actions taken. Question 10. Consider a scenario where a buyer in Florida, represented by a licensed real estate broker, is unable to secure the necessary financing for a property purchase by the contractually agreed-upon closing date, despite making a good faith effort. The purchase agreement contains a standard financing contingency clause. What is the most appropriate and legally compliant course of action for the broker to take immediately following the buyer's notification of financing failure? Option A. Immediately notify the seller in writing that the buyer cannot secure financing and that the contract may be terminated according to its terms. Option B. Advise the buyer to simply abandon the transaction and forfeit their earnest money deposit without further communication. Option C. Withhold information from the seller about the financing issue while the buyer explores alternative, unconfirmed funding sources. Option D. Suggest the buyer attempt to renegotiate the purchase price with the seller or pressure the seller into accepting a delayed closing without formal contractual amendments. The correct answer is A. Immediately notify the seller in writing that the buyer cannot secure financing and that the contract may be terminated according to its terms. Explanation. Scenario analysis. This scenario presents a common challenge in real estate transactions where a buyer's financing falls through unexpectedly. The professional challenge lies in navigating the contractual obligations, Florida real estate law, and ethical duties to both buyer and seller while managing the financial implications of the failed financing. Prompt and accurate communication, along with a clear understanding of contractual remedies and legal obligations, are paramount to avoid disputes and potential legal action. Correct approach analysis. The best professional practice involves immediately notifying the seller in writing of the buyer's inability to secure financing, as stipulated in the contract. This approach aligns with Florida Statute 475-278, which governs real estate brokerage relationships and requires licensees to act with honesty, fairness, and due diligence. Prompt written notification fulfills the licensee's duty to keep the parties informed and allows the seller to make informed decisions regarding the property. It also demonstrates adherence to the contract's terms regarding financing contingencies. Incorrect approach is analysis. One incorrect approach is to advise the buyer to simply walk away from the deal without formally notifying the seller. This fails to uphold the contractual agreement and the licensee's duty of good faith and fair dealing. It could expose the buyer to forfeiture of the earnest money deposit and potential legal action from the seller for breach of contract. Furthermore, it violates the licensee's obligation to communicate material facts to all parties. Another incorrect approach is to suggest the buyer attempt to renegotiate the purchase price without the seller's explicit agreement, or to pressure the seller into accepting a delayed closing. While renegotiation might be a possibility, it must be done through proper contractual addendums and with the seller's full consent. Unilaterally attempting to alter terms or pressure the seller circumvents the agreed-upon contract and can lead to ethical violations and legal disputes. A third incorrect approach is to withhold information from the seller about the financing issue, hoping the buyer will find an alternative solution. This is a direct violation of the licensee's fiduciary duty to disclose all material facts to their clients and to act with honesty and integrity. Concealing information erodes trust and can have severe legal and disciplinary consequences. Professional reasoning. Professionals should always prioritize clear, timely, and written communication. When faced with a financing contingency failure, the decision-making process should involve 1. Reviewing the purchase agreement to understand the specific clauses related to financing contingencies and default. 2. Immediately informing all parties in writing about the situation, adhering to contractual notice requirements. 3. Advising the buyer on their contractual rights and obligations and the potential consequences of various actions. 4. Facilitating communication between the buyer and seller to explore mutually agreeable solutions, if any exist, within the bounds of the contract and Florida law. 5. Documenting all communications and actions taken. Question 11. Upon reviewing the inspection report for a property listed by your Florida brokerage, you discover a significant, previously undisclosed issue with the foundation that will require substantial repair. The seller is aware of the issue but has not disclosed it. The prospective buyer's agent has not yet received the inspection report. What is the most appropriate course of action for your brokerage? Option A. Conceal the information about the foundation issue from the prospective buyer and their agent, assuming the seller will handle any future disclosures. Option B. Immediately inform the prospective buyer's agent and the buyer, in writing, about the foundation issue and advise the seller that this material fact must be disclosed. Option C. Advise the seller to make a superficial repair to the visible signs of the foundation issue before the buyer's agent reviews the report, without disclosing the underlying problem. Option D. Downplay the significance of the foundation issue to the seller and suggest they wait to see if the buyer's inspector flags it again before deciding on disclosure. The correct answer is B. Immediately inform the prospective buyer's agent and the buyer in writing about the foundation issue and advise the seller that this material fact must be disclosed. Explanation. This scenario is professionally challenging because it requires a broker to balance the fiduciary duty owed to their client with the legal and ethical obligations to disclose material facts, even when those facts might negatively impact a potential sale. The broker must navigate potential conflicts of interest and ensure transparency to maintain trust and comply with Florida real estate law. Careful judgment is required to avoid misrepresentation or concealment. The best approach involves promptly and fully disclosing the known material defect to the prospective buyer and their agent, in writing, while also informing the seller of the disclosure. This approach aligns with Florida Statutes Chapter 475, which mandates that real estate licensees have a duty to disclose all known material facts that could affect a buyer's decision. Full and honest disclosure protects the buyer's right to make an informed decision and shields the broker from potential liability for misrepresentation or concealment. It also upholds the ethical standard of acting with honesty and integrity. An approach that involves downplaying the defect or hoping the buyer doesn't discover it is incorrect because it constitutes concealment and misrepresentation, violating Florida Statutes Chapter 475. This failure to disclose a known material fact can lead to disciplinary action by the Florida Real Estate Commission, including license suspension or revocation, and civil liability to the buyer. Another incorrect approach would be to advise the seller to make a cosmetic fix without disclosing the underlying issue. This is a form of misrepresentation by omission. While the seller may wish to improve the property's appearance, the fundamental defect remains a material fact that must be disclosed to the buyer. The broker's duty is to disclose the truth about the property's condition, not to facilitate a deceptive presentation. Finally, an approach of waiting to see if the buyer's inspector finds the issue before disclosing is also professionally unacceptable. This passive approach still amounts to a failure to disclose a known material fact. The broker's obligation to disclose is proactive, not reactive, and begins as soon as they become aware of the defect. Professionals should employ a decision-making framework that prioritizes transparency and adherence to legal and ethical mandates. When faced with a known material defect, the immediate steps should be: 1. Confirm the defect is indeed material, i.e., likely to affect the buyer's decision or the property's value. 2. Consult Florida Statutes Chapter 475 and any relevant brokerage policies regarding disclosure. 3. Promptly and clearly communicate the defect to all parties involved, preferably in writing. 4. Advise the seller on their options and the legal implications of non-disclosure. This framework ensures compliance and fosters trust. Question 12. When evaluating multiple rental applications for a property in Miami-Dade County, Florida, a property manager receives applications from several qualified individuals. One applicant is a long-time acquaintance of the property owner, another has a slightly lower credit score but a strong rental history, and a third applicant relies on a housing voucher as their primary source of income. What is the most appropriate course of action for the property manager to ensure compliance with Florida's landlord-tenant laws and ethical property management practices? Option A. Inform the applicant with the lower credit score that their application is unlikely to be approved due to the credit score alone, without considering their strong rental history or other application components. Option B. Prioritize the application from the long-time acquaintance of the property owner, as the owner may have a personal preference, and this could streamline the decision-making process. Option C. Reject the applicant who relies on a housing voucher without further investigation, assuming that this source of income may present additional administrative burdens or risks. Option D. Review all applications against a pre-established, objective set of tenant screening criteria, documenting the evaluation process for each applicant, and present the findings to the owner for a final decision based on the objective data. The correct answer is D. Review all applications against a pre-established, objective set of tenant screening criteria, documenting the evaluation process for each applicant, and present the findings to the owner for a final decision based on the objective data. Explanation: this scenario is professionally challenging because it requires a property manager to balance the fiduciary duty owed to the property owner with the legal and ethical obligations to potential tenants, all while navigating the specific regulations of Florida real estate law. The manager must ensure fair housing practices are upheld and avoid any actions that could be construed as discriminatory or deceptive, which could lead to significant legal repercussions and damage to their professional reputation. The correct approach involves a thorough and documented review of all applications based on objective, predefined criteria. This method ensures that decisions are made impartially, adhering to Florida's fair housing laws, which prohibit discrimination based on protected characteristics. By establishing and consistently applying objective screening criteria, the property manager demonstrates due diligence and protects both the owner and themselves from potential legal challenges. This systematic process minimizes the risk of subjective bias influencing the selection of a tenant. An incorrect approach would be to prioritize a tenant based on a personal connection or a perceived gut feeling, without a formal, objective screening process. This is ethically unsound and violates Florida's fair housing regulations by introducing subjective bias, which could inadvertently lead to discrimination against applicants who belong to protected classes. Such a decision lacks the necessary documentation to justify the selection and opens the door to accusations of unfair treatment. Another incorrect approach is to reject an applicant solely based on their source of income, such as housing vouchers, without first verifying if this is permissible under local ordinances or if the applicant meets all other objective screening criteria. Florida law, and often local ordinances, Protect against discrimination based on lawful source of income. Failing to investigate this aspect or making a decision based on a blanket assumption is a violation of fair housing principles and potentially state law. Finally, an incorrect approach would be to delay the review of applications to favor a particular applicant or to avoid a thorough background check. This is deceptive and unethical, as it misrepresents the application process to other applicants and could lead to the owner selecting a tenant who does not meet the necessary qualifications, potentially resulting in future problems like non-payment of rent or property damage. It undermines the integrity of the leasing process and breaches the manager's duty to act in the owner's best interest by securing a qualified tenant. Professionals should employ a decision-making framework that prioritizes transparency, objectivity, and strict adherence to legal and ethical standards. This involves establishing clear, written tenant screening criteria before marketing a property, applying these criteria uniformly to all applicants, documenting every step of the process, and staying informed about current fair housing laws and any applicable local ordinances. Question 13. The analysis reveals a sustained period of declining property values and reduced sales volume in the Florida real estate market. A licensed Florida broker is advising a seller who is considering listing their property. Which of the following actions best demonstrates adherence to professional standards and Florida's real estate regulations in this market cycle? Option A. Urging the seller to list their property immediately at a significantly reduced price to capitalize on the perceived short-term dip before prices potentially rebound. Option B. Advising the seller that market cycles are irrelevant and that their property's value is solely determined by its intrinsic features, regardless of broader economic conditions. Option C. Assuring the seller that the market downturn is temporary and will likely reverse within the next quarter, encouraging them to hold off on selling until then. Option D. Educating the seller on the characteristics of the current buyer's market, discussing the potential impact on their property's sale price and timeline, and advising them to adjust their expectations accordingly. Correct answer is D. Educating the seller on the characteristics of the current buyer's market, discussing the potential impact on their property's sale price and timeline, and advising them to adjust their expectations accordingly. Explanation. This scenario is professionally challenging because it requires a real estate broker to interpret and apply knowledge of real estate market cycles to advise clients effectively, while adhering to Florida's specific licensing laws and ethical obligations. Misinterpreting market trends or providing unqualified advice can lead to financial harm for clients and potential disciplinary action against the broker. Careful judgment is required to distinguish between general market observations and specific, actionable advice that falls within the scope of a licensed broker's expertise and responsibilities under Florida law. The best professional approach involves a broker who, after observing a sustained downturn in the Florida real estate market, focuses on educating their clients about the current market conditions and the potential implications for their buying or selling decisions. This approach prioritizes transparency and informed decision-making by the client. It aligns with Florida Statute 475, which mandates that licensees act honestly and truthfully in all dealings and avoid misrepresentation. By presenting objective data and explaining the characteristics of a buyer's market, the broker fulfills their duty to provide competent service and acts in the best interest of their clients, allowing them to make strategic choices based on accurate market analysis. An approach where a broker actively encourages clients to rush into buying properties solely because they perceive a temporary dip in prices, without a thorough analysis of long-term trends or individual client needs, is professionally unacceptable. This could be construed as steering clients into unfavorable transactions based on incomplete or speculative market interpretations, potentially violating the duty of care and honesty required by Florida real estate law. Another professionally unacceptable approach is for a broker to make definitive predictions about the exact timing and magnitude of a market recovery. Real estate market forecasting is inherently uncertain, and making such guarantees can be considered misrepresentation or a failure to exercise reasonable care, as it sets unrealistic expectations and could lead clients to make decisions based on flawed predictions, contrary to the principles of ethical conduct and competent practice under Florida regulations. Finally, a broker who dismisses the observed market downturn as insignificant and continues with business as usual, without acknowledging the potential impact on clients' interests, fails to meet their professional obligations. This inaction demonstrates a lack of diligence and an unwillingness to adapt advice to current market realities, potentially harming clients who might benefit from a more nuanced strategy in a shifting market, and contravening the expectation of informed guidance under Florida's licensing framework. Professionals should employ a decision-making framework that begins with a thorough understanding of the current market conditions, drawing on reliable data, and recognizing the inherent cyclical nature of real estate. This understanding should then be coupled with a client-centric approach, focusing on educating the client, assessing their individual goals and risk tolerance, and providing advice that is both ethically sound and legally compliant with Florida's real estate regulations. The broker's role is to facilitate informed decisions, not to make them for the client or to predict the future with certainty. Question 14. The evaluation methodology shows that a Florida real estate broker is meeting with a prospective buyer who is eager to find a new home. The broker wants to ensure a clear understanding of their working relationship and fiduciary responsibilities. Which of the following actions best reflects compliance with Florida's real estate regulations regarding buyer representation? Option A. Reaching a verbal agreement on the terms of representation and promising to draft a formal written agreement at a later date once the buyer finds a property. Option B. Presenting a comprehensive written buyer representation agreement that clearly defines the scope of services, duration, compensation, and fiduciary duties, and thoroughly explaining its terms to the buyer before signing. Option C. Offering to represent the buyer based on the understanding that the commission will be paid solely from the seller's proceeds, without explicitly discussing the buyer's potential liability if the seller fails to pay. Option D. Informing the buyer that they can end the representation agreement at any time without needing to specify any conditions or notice periods, as this is a standard practice for buyer representation. The correct answer is B. Presenting a comprehensive written buyer representation agreement that clearly defines the scope of services, duration, compensation, and fiduciary duties, and thoroughly explaining its terms to the buyer before signing. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a real estate licensee to navigate the delicate balance between securing a buyer's commitment and ensuring compliance with Florida's specific disclosure and agreement requirements. The licensee must understand the legal implications of various agreement terms and the potential for misrepresentation or breach of fiduciary duty if not handled correctly. Florida law mandates clear, written agreements for buyer representation, outlining the duties and responsibilities of both parties. Correct approach analysis. The best approach involves presenting the buyer with a comprehensive, written buyer representation agreement that clearly defines the scope of the licensee's services, the duration of the agreement, the compensation structure, and the fiduciary duties owed to the buyer. This agreement must be reviewed with the buyer, ensuring they understand all terms before signing. This aligns with Florida Statutes Chapter 475, which emphasizes the importance of written agreements and full disclosure of material terms to protect both the buyer and the licensee. It establishes a clear contractual relationship and manages expectations, thereby preventing future disputes and ensuring ethical conduct. Incorrect approaches analysis. Presenting a verbal agreement for representation, even with a promise to formalize it later, is professionally unacceptable. Florida law requires buyer representation agreements to be in writing. This failure to adhere to statutory requirements leaves both parties vulnerable and can be construed as a violation of licensing laws. Offering to represent the buyer without a written agreement, stating that the commission will be paid from the seller's proceeds without specifying the buyer's potential liability if the seller does not pay, is also problematic. While common practice, Florida law requires explicit disclosure of the buyer's potential responsibility for compensation, especially if the seller's contribution is insufficient or not agreed upon. Failing to detail this can lead to misunderstandings and potential claims of misrepresentation. Suggesting that the buyer can terminate the agreement at any time without outlining the specific conditions or notice periods required by Florida law is also an incorrect approach. While termination clauses are important, they must be clearly defined within the written agreement to avoid ambiguity and potential disputes regarding the licensee's earned compensation or the buyer's obligations. Professional reasoning. Professionals should always prioritize written agreements that comply with state statutes. When engaging a buyer, The licensee's first step should be to discuss and present a written buyer representation agreement. This agreement should be thoroughly explained, and the buyer should be given ample opportunity to ask questions and seek legal counsel if desired. Transparency regarding compensation, duties, and termination clauses is paramount to establishing trust and ensuring a legally sound and ethical business relationship. Question 15. Implementation of a brokerage standard operating procedures in Florida dictates that when a buyer client expresses interest in a property listed by the same brokerage firm, the broker must immediately address the potential for a dual agency relationship. A buyer, represented by Agent Sarah of ABC Realty, has seen a property listed by Agent John, also of ABC Realty, and has expressed significant interest. What is the most appropriate and legally compliant course of action for ABC Realty's broker? Option A. Instruct Agent John to cease all communication with the seller regarding this buyer and have Agent Sarah proceed to negotiate solely in the buyer's best interest without further disclosure to the seller. Option B. Advise the buyer that due to the conflict, Agent Sarah can no longer represent them and suggest they seek independent representation, while Agent John continues to represent the seller. Option C. Immediately inform both the seller and the buyer in writing that ABC Realty represents both parties and obtain their written consent to proceed as either designated sales agents or a dual agent, as per Florida Statute 475. Option D. Have Agent Sarah present the buyer's offer to Agent John, who will then present it to the seller, without explicitly disclosing the brokerage representation of both parties, assuming this is a common practice within the firm. The correct answer is C. Immediately inform both the seller and the buyer in writing that ABC Realty represents both parties and obtain their written consent to proceed as either designated sales agents or a dual agent, as per Florida Statute 475. Explanation. Scenario analysis. This scenario presents a common challenge in Florida real estate where a broker's fiduciary duties can become complex when representing parties with potentially conflicting interests. The challenge lies in navigating the Florida Real Estate Commission, FREC, rules and Florida statutes, Chapter 475, regarding agency relationships, particularly when a buyer expresses interest in a property listed by the same brokerage. Maintaining client confidentiality, avoiding undisclosed dual agency, and ensuring informed consent are paramount to ethical and legal practice. Correct approach analysis. The best professional practice involves immediately identifying the potential for dual agency and initiating the disclosure process as mandated by Florida law. This means the broker must inform both the seller and the buyer of the brokerage representation of both parties. If both parties consent in writing to this arrangement, the brokerage can proceed as a designated sales agent or a dual agent with clear understanding and agreement. This approach upholds the principles of transparency and informed consent, which are cornerstones of Florida's real estate agency laws. Incorrect approaches analysis. One incorrect approach would be to proceed with showing the property to the buyer without disclosing the existing seller representation to the buyer, or without informing the seller of the buyer's interest and the brokerage's potential representation of the buyer. This failure to disclose creates an undisclosed dual agency, violating Florida Statute 475, 278, 1c, which requires disclosure of brokerage relationships. It also breaches the fiduciary duty owed to the seller by potentially prioritizing the buyer's interests without full transparency. Another incorrect approach would be to instruct the buyer's agent within the firm to act solely in the buyer's best interest without obtaining the seller's written consent to the brokerage representing both parties. While the agent might believe they are acting ethically towards their buyer client, this bypasses the requirement for the seller to acknowledge and consent to the brokerage's dual representation, as outlined in Florida Statute 475, 278(3). This can lead to claims of misrepresentation and breach of fiduciary duty to the seller. A third incorrect approach would be to withdraw the buyer's agent from representing the buyer and have them act as a transaction broker, without a clear understanding and agreement from both parties about the nature of this limited representation. While transaction brokerage is an option in Florida, it requires specific disclosure and agreement. Simply shifting roles without proper procedure can still lead to confusion and potential legal issues if the parties do not understand their rights and the brokerage's limited duties in such a capacity. Professional reasoning. Professionals should always prioritize clear, timely, and written disclosure of agency relationships. When a situation arises that could lead to dual agency, the immediate step is to review Florida Statute Chapter 475 and FREC rules. The professional must then inform all parties involved about the potential conflict and the available agency options: single agent, transaction broker, or dual agent with informed consent. Obtaining written consent before proceeding with any transaction where the brokerage represents both buyer and seller is crucial. This proactive approach minimizes legal and ethical risks and builds trust with clients. Question 16. To address the challenge of assessing the impact of economic shifts on real estate values in Florida, which approach best guides a licensed Florida broker in providing informed advice to their clients? Option A. Make definitive predictions about future property values based on a single dominant economic indicator, such as a projected increase in consumer spending. Option B. Rely primarily on national economic forecasts and general inflation rates to predict future property value changes across all Florida markets. Option C. Advise clients that real estate in Florida is always a sound investment regardless of prevailing economic conditions or market cycles. Option D. Analyze how specific Florida economic indicators, such as tourism trends, population growth, interest rate fluctuation, and local employment data, are likely to influence supply and demand dynamics within distinct Florida real estate submarkets. The correct answer is D. Analyze how specific Florida economic indicators, such as tourism trends, population growth, interest rate fluctuations, and local employment data, are likely to influence supply and demand dynamics within distinct Florida real estate submarkets. Explanation. Scenario analysis. This scenario presents a professional challenge for a Florida real estate broker because it requires them to assess the impact of broad economic shifts on local market values without resorting to simplistic or speculative predictions. The broker must demonstrate a nuanced understanding of how macroeconomic factors translate into microeconomic real estate trends within Florida, balancing client interests with ethical obligations to provide accurate, albeit potentially uncertain, market insights. The challenge lies in translating abstract economic principles into concrete, actionable advice for clients, while avoiding overconfidence or misrepresentation. Correct approach analysis. The best professional approach involves analyzing how specific Florida economic indicators, such as tourism trends, population growth, interest rate fluctuations, and local employment data, are likely to influence supply and demand dynamics within distinct Florida real estate submarkets. This approach is correct because it grounds the risk assessment in observable, jurisdiction-specific data and established economic principles relevant to real estate. Florida's economy is heavily influenced by tourism, seasonal migration, and its unique housing market characteristics. A broker must connect these macro factors to micro-level impacts on property values, rental rates, and investment potential within specific Florida regions. This aligns with the Florida Real Estate Commission's FREC emphasis on providing competent and diligent service, which includes understanding the local market and its influencing factors. Ethical practice demands that advice be based on sound analysis rather than conjecture. Incorrect approaches analysis. One incorrect approach is to solely rely on national economic forecasts without considering their specific applicability to Florida's unique market conditions. National trends may not accurately reflect the localized impacts of factors like Florida's property insurance market, state-specific tax policies, or the influence of international investment on certain Florida coastal areas. This failure to localize the analysis is a significant ethical and professional lapse. Another incorrect approach is to make definitive predictions about future property values based on a single economic indicator, such as a general rise in inflation. While inflation can impact real estate, its effect is complex and mediated by many other factors, including interest rates, consumer confidence, and local supply-demand imbalances. Offering such a singular, deterministic prediction is speculative and potentially misleading, violating the duty of care owed to clients. A third incorrect approach is to dismiss the influence of economic factors altogether, asserting that real estate is always a good long-term investment regardless of market conditions. This stance ignores the inherent risks and cyclical nature of real estate markets, particularly in a diverse and dynamic state like Florida. It demonstrates a lack of due diligence and an unwillingness to provide clients with a realistic assessment of potential risks and opportunities. Professional reasoning. Professionals should adopt a systematic risk assessment framework that begins with identifying relevant economic factors at both national and, crucially, state and local levels. For Florida, this includes analyzing tourism, migration patterns, employment sectors, e.g., hospitality, technology, agriculture, interest rate impacts on affordability, and the state's unique insurance market. The next step is to evaluate how these factors interact to influence supply and demand for different property types in specific Florida submarkets. This involves consulting reliable data sources, understanding market cycles, and considering potential future scenarios. Finally, professionals must communicate these findings to clients clearly and transparently, outlining potential risks and opportunities without making guarantees, thereby fulfilling their fiduciary and ethical obligations. Question 17. Examination of the data shows a Florida real estate investor is seeking financing for a property acquisition and is interested in options that offer speed and flexibility. They have inquired about hard money loans and seller financing. What is the most prudent course of action for a Florida licensed real estate broker to advise this investor? Option A. Advise the investor to proceed with seller financing, suggesting they can negotiate directly with the seller without involving legal professionals, as this is a common and straightforward transaction. Option B. Provide a detailed comparison of hard money loans and seller financing, outlining the typical terms, interest rates, repayment structures, associated risks and benefits of each, while strongly recommending the investor consult with a qualified real estate attorney and a financial advisor to finalize their decision. Option C. Offer to draft the promissory note and mortgage documents for seller financing, emphasizing the flexibility of these arrangements and downplaying the need for extensive legal review. Option D. Recommend a hard money loan as the primary option due to its reputation for quick closing times, assuring the investor that the speed of acquisition outweighs potential higher costs. Correct answer is B. Provide a detailed comparison of hard money loans and seller financing, outlining the typical terms, interest rates, repayment structures, associated risks and benefits of each, while strongly recommending the investor consult with a qualified real estate attorney and a financial advisor to finalize their decision. Explanation. This scenario presents a professional challenge because it requires a Florida real estate broker to balance the client's desire for a quick, flexible financing solution with the fiduciary duty to ensure the client understands and mitigates the inherent risks associated with hard money loans and seller financing. The broker must act with competence and diligence, providing accurate information and guidance without engaging in the unauthorized practice of law or providing financial advice beyond their licensing scope. Careful judgment is required to identify the most suitable financing option based on the investor's specific circumstances and risk tolerance, while adhering to Florida's real estate licensing laws and ethical standards. The best approach involves thoroughly educating the investor about the distinct characteristics, advantages, and disadvantages of both hard money loans and seller financing, specifically within the context of Florida real estate transaction. This includes explaining the typically higher interest rates and shorter terms of hard money loans, the potential for faster closing, and the increased risk of foreclosure if payments are missed. For seller financing, the focus would be on the negotiation flexibility, potential for lower upfront costs, and the importance of clearly defined terms in the promissory note and mortgage, all while ensuring the investor understands they are entering into a contractual agreement that requires legal review. The broker's role is to facilitate understanding and ensure the investor is making an informed decision, recommending they consult with legal and financial professionals for personalized advice. This aligns with Florida Statute 475, which mandates brokers to act honestly and truthfully and to exercise reasonable care and diligence. An incorrect approach would be to recommend a hard money loan solely because it offers a faster closing, without adequately discussing the significantly higher costs and risks involved, potentially leading the investor into a detrimental financial situation. This fails to meet the duty of care and honesty required by Florida law. Another incorrect approach would be to draft the terms of a seller financing agreement without advising the investor to seek independent legal counsel. This could be construed as the unauthorized practice of law, a violation of Florida Statute 455. 627, and exposes the investor to poorly structured agreements that may not protect their interests. Furthermore, presenting seller financing as a universally easier option without detailing the complexities of loan servicing, default procedures, and potential legal entanglements would be misleading and unprofessional. Professionals should employ a decision-making framework that prioritizes client education and risk mitigation. This involves a comprehensive needs assessment, followed by a clear explanation of available financing options, their associated risks and benefits, and the importance of independent legal and financial counsel. The broker's responsibility is to guide the client through the process of understanding these options, not to make the decision for them, or to provide services that fall outside their licensing authority. Question 18. A Florida real estate broker is assisting a buyer who is pre-approved for a conventional mortgage but has a down payment of 10%. The broker knows that private mortgage insurance, PMI, will likely be required. Which of the following actions best fulfills the broker's professional and legal obligations regarding PMI disclosure to the buyer? Option A. Inform the buyer that PMI will be required due to the low down payment and advise them to discuss all details with their mortgage lender. Option B. Assure the buyer that PMI is a standard part of the loan and not a significant factor to worry about, as it will eventually be removed. Option C. Proactively explain to the buyer the purpose of PMI, its estimated cost as a percentage of the loan, and the conditions under which it can be canceled or terminated according to federal law and Florida's disclosure requirements. Option D. Provide the buyer with a generic pamphlet on mortgage insurance, without specific details about their situation or cancellation rights. The correct answer is C. Proactively explain to the buyer the purpose of PMI, its estimated cost as a percentage of the loan, and the conditions under which it can be canceled or terminated according to federal law and Florida's disclosure requirements. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires a Florida real estate broker to navigate the complexities of private mortgage insurance, PMI, disclosure requirements for a client seeking a mortgage. The challenge lies in ensuring the client fully understands the implications of PMI, its cost, and the conditions under which it can be removed, all while adhering to Florida's specific disclosure laws and federal regulations. Misinformation or incomplete disclosure can lead to significant financial repercussions for the buyer and potential liability for the broker. Correct approach analysis. The best professional practice involves proactively educating the client about PMI, its purpose, and the associated costs. This includes clearly explaining that PMI is typically required for conventional loans when the down payment is less than 20% of the property's value. Furthermore, the broker must inform the client about the conditions under which PMI can be canceled or terminated, such as reaching a certain loan-to-value ratio, typically 80% for cancellation and 78% for automatic termination, or providing a new appraisal. This approach aligns with Florida's statutory duty for real estate licensees to exercise reasonable care and diligence, act with fairness and honesty, and disclose all material facts that could affect a buyer's decision. It also implicitly addresses federal requirements under the Homeowners Protection Act of 1998, which mandates specific disclosures and cancellation rights for PMI. Incorrect approaches analysis. Providing only a general statement that PMI might be required without detailing its purpose, cost, and cancellation terms is a failure to provide adequate disclosure. This approach omits crucial information that directly impacts the buyer's financial understanding of the loan. Failing to explain the conditions for PMI cancellation is also a significant omission, as it deprives the buyer of knowledge about a potential future cost saving. Suggesting that PMI is always a permanent loan feature is factually incorrect and misleading, violating the duty of honesty and fair dealing. Lastly, advising the client to solely rely on the lender for all PMI information, while lenders do have disclosure obligations, absolves the broker of their independent duty to ensure the client is fully informed about a material aspect of their financing, which could be influenced by the property transaction. Professional reasoning. Professionals should adopt a client-centric approach, prioritizing transparency and comprehensive education. This involves anticipating potential client questions and proactively providing relevant information, even if not explicitly requested. A thorough understanding of both state-specific disclosure laws and relevant federal regulations is essential. When dealing with complex financial instruments like PMI, brokers should err on the side of overdisclosure, ensuring clients have all necessary information to make informed decisions. This proactive and educational stance not only fulfills legal and ethical obligations, but also builds trust and mitigates risk. Question 19. Which approach would be most prudent for a Florida real estate broker when a client expresses a strong desire for the lowest possible initial monthly mortgage payment, potentially overlooking long-term financial implications? Option A. Focus solely on finding properties within the client's absolute maximum affordable price range, assuming the client has fully considered all mortgage product risks. Option B. Thoroughly explain the characteristics and risks of fixed-rate, adjustable-rate, and interest-only mortgages, assess the client's financial stability and long-term goals, and recommend the mortgage type that best balances affordability with manageable risk. Option C. Advise the client to pursue an interest-only mortgage, emphasizing the significant reduction in immediate out-of-pocket expenses. Option D. Immediately recommend an adjustable-rate mortgage, highlighting its lower initial interest rate and monthly payment as the primary benefit to meet the client's stated preference. The correct answer is B. Thoroughly explain the characteristics and risks of fixed-rate, adjustable-rate, and interest-only mortgages, assess the client's financial stability and long-term goals, and recommend the mortgage type that best balances affordability with manageable risk. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a real estate licensee in Florida to balance a client's immediate financial desires with the long-term implications and potential risks of different mortgage products. A client seeking to minimize initial payments might be drawn to options that carry higher future risk, necessitating careful guidance and disclosure to ensure the client makes an informed decision aligned with their financial stability and Florida's real estate regulations. Correct approach analysis. The best professional practice involves thoroughly explaining the fundamental differences between fixed-rate, adjustable-rate, and interest-only mortgages, focusing on how each impacts long-term affordability and risk. This includes detailing how interest rates fluctuate with adjustable-rate mortgages, the potential for payment shock, and the fact that interest-only loans do not build equity. The licensee must then assess the client's financial situation, risk tolerance, and long-term goals to recommend the mortgage type that best aligns with their capacity to manage future payments and their overall financial well-being, ensuring full compliance with Florida's disclosure requirements under Chapter 475, Florida statutes, and related administrative rules which mandate licensees to act with honesty, fairness, and full disclosure. Incorrect approaches analysis. Recommending an adjustable-rate mortgage solely because it offers a lower initial payment without a comprehensive discussion of future rate increases and potential payment shock would be a failure to adequately inform the client of material risks, potentially violating Florida's duty of care. Suggesting an interest-only mortgage without a clear understanding of the client's plan for principal repayment and their ability to handle future principal and interest payments would also be a significant ethical and regulatory lapse, as it could lead to financial distress and foreclosure, contrary to the licensee's fiduciary duty. Focusing exclusively on the lowest possible monthly payment without considering the client's long-term financial stability and the potential for payment increases inherent in non-fixed-rate products demonstrates a lack of due diligence and a failure to act in the client's best interest, which is a cornerstone of Florida real estate licensure. Professional reasoning. Professionals should approach such situations by prioritizing client education and risk assessment. The decision-making process should involve 1. Understanding the client's stated needs and underlying financial capacity. 2. Clearly articulating the features, benefits, and risks of all relevant mortgage products. 3. Guiding the client toward a product that aligns with their financial stability and long-term objectives, not just their immediate desires. 4. Documenting all discussions and recommendations to demonstrate adherence to professional standards and regulatory requirements. Question 20. Governance review demonstrates that a Florida property management firm is experiencing a high rate of tenant defaults. To mitigate this risk, the firm's managing broker is considering implementing a new tenant screening protocol. The firm receives an average of 20 applications per available unit. For a particular unit, the broker wants to assess an applicant's financial capacity to pay rent. The applicant's gross monthly income is $4,500. Their recurring monthly debt payments excluding rent total $1,200. The target rent for the unit is $1,500 per month. What is the applicant's debt-to-income ratio expressed as a percentage based on this information? Option A, 26.67%. Option B, 33.33%. Option C, 60.00%. Option D, 50.00%. The correct answer is B, 33.33%. Explanation: scenario analysis. This scenario is professionally challenging because it requires a Florida real estate broker to balance the business need for efficient tenant screening with the legal and ethical obligations to avoid discriminatory practices. The broker must implement a system that objectively assesses applicant risk, while strictly adhering to the Fair Housing Act and Florida's specific landlord-tenant laws. Failure to do so can result in significant legal penalties, reputational damage, and harm to protected classes. Correct approach analysis. The best professional practice involves developing a standardized tenant screening process that uses objective, quantifiable criteria applied consistently to all applicants. This approach ensures that decisions are based on financial responsibility and rental history, not on protected characteristics. For example, calculating a debt-to-income ratio provides a clear, numerical measure of an applicant's ability to afford rent, directly addressing financial risk. This aligns with the Fair Housing Act's prohibition of discrimination based on race, color, religion, sex, familial status, national origin, or disability, and Florida Statutes Chapter 83, which governs landlord-tenant relationships, by focusing solely on legitimate business concerns. Incorrect approaches analysis. One incorrect approach involves relying on subjective assessments and personal gut feelings about applicants. This is ethically problematic because it opens the door to unconscious bias, which can lead to discriminatory outcomes that violate the Fair Housing Act. There is no objective basis for such judgments, making them impossible to defend against accusations of discrimination. Another incorrect approach is to prioritize speed of filling vacancies over thorough, objective screening. While efficiency is important, rushing the process without applying consistent criteria can lead to overlooking red flags or, conversely, making assumptions that could be construed as discriminatory. This approach fails to mitigate the risk of selecting a problematic tenant or unfairly rejecting a qualified one. A third incorrect approach is to use screening criteria that, while seemingly neutral, have a disparate impact on protected classes and are not demonstrably related to business necessity. For instance, an overly stringent credit score requirement that disproportionately excludes individuals from certain demographic groups without a clear justification tied to rental risk could be challenged as discriminatory under fair housing principles. Professional reasoning. Professionals should adopt a decision-making framework that prioritizes compliance and fairness. This involves 1. Understanding and internalizing all relevant federal and state fair housing laws and landlord-tenant regulations. 2. Developing a written tenant screening policy with clear, objective, and consistently applied criteria. 3. Utilizing standardized application forms and screening tools. 4. Training all staff involved in tenant selection on fair housing laws and the company's screening policy. 5. Regularly reviewing the screening process to ensure it remains effective, compliant, and free from bias.